Tony DeWitt here, Missouri appellate attorney, retired. None of what follows is legal advice. I'm here to do some video for you today to talk about an interesting subject on the law, and here it is. The majority of cases that affect our substantial constitutional rights don't originate at the Supreme Court, or I should say they're not decided at the Supreme Court. Most of the time, those cases arise in the district courts. They get sent up to the U.S. Circuit Court of Appeals, and that's the end of the discussion. That's one of those cases today, and it's worth taking a look at. Now, I'm sure many of you all remember when COVID was going on, how the government insisted that anybody who was in the military, anybody who was in healthcare, all of these folks had to take the COVID vaccine. And of course, now later information has disclosed that there are a number of side effects with that, a number of risks with taking that vaccine. But at the time, it seemed like the prudent course for the government to take the position that anybody in the military would need to take this vaccine because you don't want to have your entire fighting force coming down with a serious and potentially deadly disease. All of the services imposed a vaccine mandate. And one of them, of course, was the Air Force. And there was supposed to be a provision for religious exemptions. And that's what this case is all about. So this is Faith Crocker, among others, versus Lloyd Austin, among others. It's from the Fifth United States Circuit Court of Appeals. One of the problems that is frequently talked about in legal circles is forum shopping. And that's where you go to a place where it has only a small connection to the litigation. Well, as you can see from this map of the Fifth Circuit and those black dots that I've put on it, that's about half of the number of military installations that are located in the Fifth Circuit, which is the brown area down there at the bottom of the map. So no forum shopping in this case. As I said, the case involves military personnel challenging the COVID-19 vaccine mandate and the way it was enforced by the United States Air Force. And it does touch on religious accommodations and administrative procedures in the military. And as somebody who worked in the Army in an administrative role at one point, I have to tell you that a lot of the guidelines and a lot of the regulations just sort of fall by the wayside when there hasn't been anything that, presents a clear historical antecedent to something like the COVID-19 pandemic. At no other time in our history has our entire military been exposed to a potentially deadly virus. So a lot of the regulations, including I think some of the religious accommodation regulations, just went out the window. There are two primary legal issues in the case. The first was standing. And we see standing all the time. It basically means you have a concrete, particularized interest in having this matter decided by the court. And the first one was whether Byron O. Starks, who was separated from the Air Force, had a legal right, the standing, to challenge the vaccine mandate. The second issue was mootness, whether the claims of all the other plaintiffs who were still serving in the Air Force became moot after the military rescinded the COVID-19 mandate. And I think you might be surprised at how the Fifth Circuit resolves that issue, or both issues, actually. So in 2021, the Department of Defense imposed this COVID-19 vaccine mandate, and it was enforced by the Air Force Secretary, Frank Kendall, and 7 service members, including Faith Crocker and Byron Starks, refused the vaccine based on their sincerely held religious beliefs. They requested religious exemptions, but these requests were denied by the Air Force. The exemptions were denied for almost everybody, and I think that's an important point that doesn't really get talked about at great length in this case, but generally speaking, one of the things that they threw out when they were throwing the baby out with the bathwater, one of the babies that they threw out was religious exemptions. It's like, we don't care what your religious beliefs are. If you want to be in our military, you're going to have to change your religious beliefs. And of course, they really can't do that. The plaintiffs sued the Department of Defense under the First Amendment and the Religious Freedom Restoration Act and the Administrative Procedure Act. Starks was discharged from the Air Force in June of 2022. The Air Force claimed that it was for a pre-existing medical condition, but Starks alleged it was due to his refusal to comply with the vaccine mandate. In December of 2022, Congress passed the National Defense Authorization Act, which required the rescission of the vaccine mandate. And despite that rescission, the plaintiffs continued to pursue the case, arguing that their rights were still being violated. And they had an interesting argument in that regard. With regard to Starks, they said, look, he was separated, but they gave him a less than honorable discharge, meaning they gave him a general discharge. And it affected his veterans' benefits, such as ineligibility for the GI Bill, ineligibility for VA loans, ineligibility in some cases for VA medical care. And so there was a continuing ongoing harm, and so Starks had, that was their argument, Starks had standing. And then ongoing harm for the other plaintiffs. The plaintiffs argued that the Air Force religious exemption process was discriminatory. They alleged the process was designed to deny all or almost all of the religious exemptions, making it a sham process. They also claimed that the Air Force practices could continue to harm them in the future when it comes to religious accommodations for other vaccines or other issues where religious exemptions are appropriate. They do have to have a process to account for religious accommodations. So the defendants argued that Starks was separated because he had this pre-existing medical condition that was completely unrelated to COVID-19. And they claimed that since Starks was no longer in the military, he lacked standing to challenge the vaccine mandate. In other words, because we kicked him out before you ruled, he shouldn't be allowed to appeal. Which doesn't exactly sound like a very fair approach to me, but hey, what am I? I'm just a lawyer. Mootness for the other plaintiffs. They said, look, this is moot. We've rescinded the policy. There's no live controversy here. We're just, you don't have to worry about this. We're not going to do this again. There's not going to be a COVID vaccine mandate. And for that reason, this is moot. Let's move on. But of course, one of the provisions in the federal law with regard to mootness is that a moot case can still be reviewed if it is susceptible to being repeated. In other words, it could happen again and it's capable of evading review, meaning that if they just change the policy when they get to the 11th hour in front of a court, that doesn't prevent it from being reinstated later on and forcing people to come back and sue again. So, at any rate, these are the two things that they argued. The separation meant that he didn't have standing, and that the case was moot as to the other plaintiffs. Now, the U.S. Court of Appeals for the Fifth Circuit reversed the district court's dismissal and ruled in favor of the plaintiffs on two key points. For standing for Starks, they said, look, he has standing because he sufficiently alleged that his discharge was related to his refusal to take the vaccine. And the effects of that discharge, such as the loss of veterans' benefits, they continue to harm him and will continue to harm him ad infinitum. And then they said it's not moot for the other plaintiffs because the rescission of the vaccine mandate didn't address the broader issue of the Air Force's religious exemption process. The religious exemption process still is a part of the Air Force policies and procedures. The court also decided that the plaintiffs argued that the broader issues related to this Air Force policy and procedure of exemptions on a faith-based process were ongoing, and as a result, they could not be moot. Here's the reasoning behind the court's decision. The court said that Starks had sufficiently shown injury because he was discharged soon after his refusal to take the vaccine. The court noted that his general discharge, meaning less than honorable, impacted his eligibility for benefits, which constituted a lasting harm, and Starks had the right to challenge that discharge. In other words, the Fifth Circuit went right down the line with the plaintiffs on that issue. And then the court reasoned that while the specific COVID vaccine policy had been rescinded, the plaintiff's broader claim about the religious exemption process being a sham was still relevant. The court pointed out the plaintiff's alleged ongoing harm because they believed the Air Force's accommodation process was designed to systematically deny religious exemptions. In other words, it was a sham. They also expressed concern that future vaccines might come up and how that same process might be used again. Now, the case has significant implications for the military and how it handles religious accommodation, because it's an administrative process in the armed forces. So it clarifies that service members discharged under contested circumstances can still challenge those decisions, especially if their discharges have lasting effects. So perhaps if Mr. Starks was, for whatever reason, given an honorable discharge as opposed to a general discharge, he might not have had standing to challenge the issue. And that such a rescinded policy doesn't necessarily moot a case if there are broader issues and ongoing or system problems and how religious accommodations are handled. In other words, this issue of systematically denying religious exemptions was something that was driving the court's holding in this case. These are the kind of cases that I think are interesting from the standpoint of what they mean to not only the people in the Air Force, but the Marines, the Navy, the Army, Coast Guard. I think you could adopt much of this reasoning for anybody who is affected by this Defense Reauthorization Act. And as a result, this case is going to have significant implications. Now, it was just decided, and of course, the government has a period of time, I believe it's up to 90 days, to seek certiorari and review by the Supreme Court, and they may indeed do that. But if they were wise, they would not do that, because all that's going to do is bring up how heavy-handed this policy was at the time. I think this is an issue that is better left done. So that's what I have for you today. It's a little shorter than usual, but I thought it was an interesting case, and I thought perhaps you guys might enjoy hearing about what the Fifth Circuit decided in this case, especially since it deals with faith-based accommodations and religious exemptions. If you have any questions, drop them in the comments down below. Like, share, subscribe, all that stuff. You can email me if you want to at the address up there. And if you have the opportunity today, go out of your way, do something nice for somebody. And then, when you're done, come on back tomorrow. We'll talk about something else. Hey, as I said at the beginning, none of what I said is legal advice. But let me tell you what, the stuff that's going to be right up here, these are the things that YouTube thinks you might be interested in going forward. Have a terrific day.